I usually am very transparent with you guys about, probably too much, about all sorts of things. As you know, about a year ago, unDivided, with the Citizen Action Defense Fund, filed a public records lawsuit against the city of Seattle. The case centered around a now former Seattle City Councilman, Andrew Lewis, and his vote at the last minute to kill a drug possession ordinance. Now, if you're familiar with the ins and outs of the lawsuit, I just want to catch people up if you're not. Basically, we wanted to know why Andrew Lewis had, at the very last minute, changed his vote. He was expected to be a yes vote. Literally on the dais, he says, shocks everyone, being the deciding no vote. We file a very simple, very narrow public records request for emails, phone calls, voicemails to and from the councilman to see who, if anyone, was influencing him. Now, this request became very suspicious very quickly, in my estimation, because they told us the first installment would be available after the primary election, just days after the primary election that Andrew Lewis was on the ballot for re-election. And then they told us that the second installment would be available just days after the general election. I've done hundreds of public records requests in my career. That was a very, very suspicious thing. And so the Citizen Action Defense Fund agreed to file a lawsuit against the city of Seattle in this case. And ever since then, as you know, I've talked very little about it. I always get asked for updates, and it's because I want to respect the judge in the case, the process, and I want it to be decided on its merits. I don't want it to be decided based on my ramblings on my talk show. So what you don't know is that a month ago, a judge in Seattle, a King County Superior Court judge, ruled against us in this public records suit. But the ruling that she handed down is actually very interesting and kind of conflicting, in my opinion. So basically, this judge in her ruling agreed that there was ample evidence to show that the city of Seattle did not follow its internal procedures and policies for responding to public records requests. It was unnecessarily delayed. They weren't filling vacancies in their public records unit, et cetera, et cetera. But what the judge ruled is that just because we can show, or you can show, that the city violated its own policies, that's not necessarily a violation of the Public Records Act. In her ruling, the judge wrote, the city's internal policies and procedures do not create law or constitute a per se violation of the PRA. However, a failure to enforce reasonable rules that provide for fullest assistance to inquirers may give rise to liability under the PRA if it leads to unreasonable delays in production and non-responsiveness. However, the court finds that when viewing the facts in the light most favorable to the plaintiff, there is no evidence sufficient to create a genuine issue of material fact as to whether the city complied with the Public Records Act. Now, here's why that's so troubling. So the Public Records Act, which came about because voters passed it in the 1970s, because they understood the need for transparency and oversight, and that anyone, whether you're a citizen or a journalist, should have access to the records of the people who serve them. So when the Public Records Act was passed, it also, in the law, has a requirement that agencies, cities, counties, state agencies, they have to craft policies and procedures that spell out how they are going to respond to public records requests in a reasonable and timely manner. It's called providing fullest assistance. So here you have a situation where, by their own admission in depositions, the city of Seattle acknowledges that it did not follow those policies that it has. It did not follow its internal policies and procedures, yet here you have a judge saying, well, that's okay. That doesn't amount to a violation of the Public Records Act. Well, we obviously fundamentally disagree, because that would lead us all down a very slippery slope when it comes to government transparency. If this ruling, in our opinion, is allowed to stand, it basically says that cities and counties and agencies, they can have policies and rules on the books, but they don't have to follow them. And for a city like Seattle that has a pretty troubling track record when it comes to public records requests, this is going to allow them to continue to play fast and loose with the law and continue to erode the spirit of transparency that the Public Records Act was all about. So we're happy to announce today that it is with hope for a better outcome, that unDivided Media and the Citizen Action Defense Fund are appealing this decision from a King County judge to the Washington State Supreme Court. Our attorney, Jackson Maynard, joins us today to discuss. Why did you feel like, despite the ruling in King County Court, that this was something worthy of appeal?
It's worthy of appeal because the Public Records Act is important. It really is the foundation of transparency and government accountability. It's the ability of you and the media, but also the people to have the information that they need to be able to hold their government leaders accountable. And so the court ruling was very surprising in terms of its potential impact to the Public Records Act. And so we just felt like, in looking at it, looking at the law, we needed to go ahead and take this up and get another court to take a look at it.
Yeah, and you speak legal better than I do, obviously. And so tell me if I'm mischaracterizing the judge's ruling in this case, because I came to court when you made your final argument in this case. I obviously thought it was very sound, but the judge seemed to understand the points we were making about the question she asked led us to believe, I think, she understood the central issue, which we'd now be asking the high court to consider, which is, the law, the PRA passed by voters, it says that agencies have to have policies and procedures in place, internal rules for responding to requests. And by the city of Seattle's own admission, they didn't respond to this request in line with their own policies. So I think the central question, and this is where we obviously disagree with the ruling, is basically not following your policies and procedures doesn't mean you violated the PRA.
Yeah, I think that's the effect of the judge's ruling, and that's really, really problematic because it sends a signal to agencies that they don't have to follow their own rules that the PRA says they have to set up. The Public Records Act says that they have to pass and promulgate rules that they use and policies that they use to help guide it, so that everybody knows how these Public Records Acts are supposed act requests are supposed to be handled. But it also says they have to enforce them. And we found through the course of our litigation, and the city fought us tooth and nail. First they tried to dismiss the whole thing. We won that. Then they said, "Oh, well, we don't want you to do discovery," and we won that. We were able to prevail and fight for our right to depose people. And as we deposed many of the staff and the folks at the city, we found, and former staff, we found that they had some really key violations of how your public records requests were handled that led to, directly contributed to the delay and the fact that you didn't get all the records until after the election. And it's not that they were all pretty much available, the record is clear, in July. And yet, for whatever reason, in part because they violated their own rules, they didn't provide you all of the records until November. So there were a lot of discrepancies and just a lot of violations, and we laid them out for the judge. She admitted in her order that they had violated those rules and policies, but for whatever reason was not willing to hold them accountable by enforcing the act, and that's why we're appealing.
You have a city that has kind of a troubling track record when it comes to public records. I mean, the whole missing text messages debacle comes to mind. And so it's sort of, if this ruling stands, it feels like you have all these agencies that can just respond to requests as they see fit, not follow their own policies and procedures. And it's such an erosion of the spirit of the law.
It is, and it really creates a circumstance in which, and we pointed to this in the cases we cited. You may recall we referred to the Cantu case, which was out of Yakima, and it was a really horrible situation. A mom in Yakima, her kid was being bullied, and she just wanted the records, and the agency sat on it for months and months and refused. They never actually provided her all the records. They never closed the case until after she had to sue. And so what the court in that case said is, look, you can create a delay. Yeah, they provided the records eventually, but that's not the issue. There is a constructive delay that occurs when an agency takes so long for no good reason in violation of their own policies to respond. And that's what happened in your case. And so that's what we're hoping the state Supreme Court will see as well.
Yeah, I mean, it seems pretty cut and dry to me. I'm not a judge, I'm not an attorney, but it's in the law. It has to be in the law for a reason, and so not following it should be a violation of the law. Jackson, just in layman's terms, what happens from here?
Sure. So we filed the notice of appeal today. In, I believe, 15 days, we will do another document that is a statement of grounds where we lay out for the court why, under the rules of appellate procedure, they should take this case. They will have the option, it's a discretionary thing for the court. So they will have the option of either accepting review of the case, or they can send it to the Court of Appeal, in which case we'll have an opportunity to make arguments there. So
All right.
that's the timeline.
Well, we thank you and the Citizen Action Defense Fund for really sticking with this and fighting for transparency and oversight. It's hard as a longtime journalist to see, again, how I characterize as just sort of the erosion of the spirit of the Public Records Act, which voters passed for a reason. And, cases like this, I think, are important to maintaining the integrity of that act. So we appreciate it.
Thank you for fighting with us, and thank you for being my favorite client, Brandi.
Good. How could I not be someone's favorite client, right? Total gem. No, that's Jackson Maynard with the Citizen Action Defense Fund. And I will say, one of the things that really worries me about this and about this becoming the standard to say, oh, totally fine not to follow your own policies and rules, is you're essentially giving, all this leeway to these agencies. When they set the rules and policies, citizens should be able to reasonably believe that if they file a public records request, those rules and policies are going to be followed. And for citizens, or even journalists, frankly, who don't submit a lot of public records requests, they might not understand that the delay that they're experiencing is unreasonable, or that the delay they're experiencing is because you have a city agency or a government agency that's not following its own rules and procedures. So it basically means you have to sue. You have to know, first of all, that it's weird. I mean, like I said, I've done hundreds of these. And so instantly it's like, that's not normal. But you'd have to know, to recognize that, and to sue over it. You have a lot of citizens who don't have the means, who don't have the connections to be able to mount some sort of legal challenge. That's not reasonable to expect that of citizens or the media. What's reasonable is to expect that government agencies are abiding by the spirit of the law. And so that is what we're hoping the state Supreme Court will agree with us on, and we will keep you up to date on how the lawsuit progresses. What I won't do is overly opine about the decision making by judges or justices if it gets there while it's ongoing, because I want to be respectful. This is one of those rare examples, not that I want to be respectful very rarely, but this is one of those rare examples where, I'm not going to be quite as I guess, transparent as you would see as the process goes along, just out of respect for the process. But I do want to, again, give credit to the Citizen Action Defense Fund. We're not paying a dime for this legal defense. They're doing this pro bono, and they are supported by donation. So if you're interested in supporting Citizen Action Defense Fund, you can go to citizenactiondefense.org. They're also, by the way, representing pro bono, the WSDOT whistleblower, that case going to trial, who says that the state fired him because he said, yeah, Jay Inslee, the CCA is going to increase gas prices. And he didn't get, I think he resigned under pressure, basically, rather than getting fired. But so they do a lot of important work. So thank you to CADF.